This meeting is being recorded. This meeting is being transcribed.
Good morning. It is Tuesday, December the 12th, 2023, and I'd like to call the Board of Funeral Directors and Embalmers meeting to order. And first thing on our agenda, you'll notice the public comments form is there in the back if anyone would like to sign in to do so. And Ms. Bohannon, I'll ask that you call the roll, please.
Fred Berry.
Present.
Anthony Harris.
Here.
Tanya Scale-Haynes.
Here.
Chris Lee.
Here.
Wendell Naylor.
Here.
Scotty Porsche. Pam Stevens. Mr. President, we have a quorum.
Thank you, Ms. Bohannon. Board members, you do have the agenda before you, and we'll accept a motion to accept as presented.
So moved.
Second. All right. I have a motion by Mr. Berry, second by Mr. Lee to accept our agenda. Any further questions? If not, all in favor say aye. Aye. Any opposed? All right. We have the minutes before us for the November 14th, 2023 meeting. We'll take a few moments to review those with any additions, deletions, or corrections.
Move they be approved.
Second. All right. We have a motion by Mr. Berry, a second by Mr. Lee to approve the November 14th, 2023 board meeting minutes. Any further questions or discussion? If not, all in favor say aye. Aye. Any opposed? All right. We will turn to Mr. Bryant for our legal report. Good morning, sir.
Good morning, board members. The first complaint we have is case number 2023-04-8881. This complaint was administratively opened on October 2nd, 2023, following an inspection conducted by the department on September 27th, 2023. This inspection occurred due to an ownership and name change of respondent establishment and follows an inspection conducted on April 12th, 2023. During the course of the April 12th, 2023 inspection, it was discovered that an individual who had signed most, if not all, of the permits for cremation of human remains on behalf of respondent establishment was not a licensed funeral director. Since the last inspection, ranging from April 13th, 2023 to September 27th, 2023, the inspector noted that approximately 86 cremations had been performed at this location, with the same unlicensed individual signing most, if not all, of the permits for cremation of human remains. Respondent replied acknowledging that the findings were accurate, offering that their only defense was that he, the owner, and none of the funeral directors knew that the person overseeing and signing the cremation papers had to be a licensed funeral director. Respondent added that although the individual who signed the documents was not a licensed funeral director, he was a certified crematory operator. Respondent also offered that a licensed funeral director was on the premises of the establishment at all times. Based on the above, the board previously issued a $750 civil penalty for violations of the unauthorized individual signing the necessary documentation and an expiration of the funeral director's license for the period from February 28, 2023 to April 3, 2023. The suggested civil penalty represents an increased civil penalty for the one violation of having an unlicensed individual sign for pertinent documentation, as there was no violation found for expired license during this inspection. So we'd recommend a $500 civil penalty, authorized via consent order, and a formal hearing if necessary.
You're saying the disciplinary $750 that they had this year, they have signed and paid that?
They have, yes.
Was the additional the $500 civil penalty recommendation here, is that for the 86 cremations that were signed off on?
That is, yes.
I know we tried to get the word out. I think we had a case similar to this back in the spring, and I guess need to say it again for folks listening that'll watch, that the certified crematory operator does not relieve the funeral director status of being back there. I know this is the second case that I've heard, so maybe that word will kind of get out to everybody.
So after the 750 civil penalty was issued, it was discovered that, and they realized that they were not in compliance, did they immediately stop performing cremations, or did our investigators look into that?
Yeah, so what appears to have happened, and I will say a little bit of the timing is not in their favor of, we did just our normal annual inspection back in April at this location, found that, someone not licensed as a funeral director was signing that documentation. So they got their citation, and then they start to move towards the process of selling this location. So we have to do another inspection, even though we just did one somewhat recently. So kind of during this period, they got hit for allowing that individual to sign in April, and then essentially kind of continued business as usual up and until September, I believe 27th, when this inspection took place. So they kind of continued. I will say that when we see a delay of when our inspectors turn those reports around as quickly as they can, just the complaint process adds time to that. So by the time they had gotten the consent order saying, hey, that's a violation, that's not okay, it had been fairly long in the month. I'm not positive when they got that, but very long-winded way to answer your question of, yes, they continued to do that for that stretch of time from April to September. And our inspection found that. So is essentially you had a violation for it in April, and we're upping the civil penalty amount this time since that's a consecutive violation.
Well, even after the consent order, they continued to do some?
So my understanding I can double check when that exact date was, but the timing usually makes its way of, they'll write their report. The investigator takes them a little bit of time, usually a week or so. Then a complaint's filed with our department. The respondent has a 2-week window to respond. That takes some time. It needs to fall on the calendar to be presented here. So there can be large stretches of time between when an inspection takes place to when they receive a consent order. So I think my recollection is that by the time that consent order was signed and settled, this investigation had just taken place or was about to take place, or it was kind of a quick turnaround in that time.
For a reason why we don't have a matching penalty there, I mean, they continued, if I understand right, with 86 cases.
Part of that 750, was that the expired funeral director's license or expired license?
It was, yes.
Okay.
I'll move we approve council's recommendation.
I'll second.
All right, I have a motion by Mr. Berry to accept legal's recommendation, $500 civil penalty authorizing via consent order and formal hearing if necessary, second by Mr. Lee. Any further questions or discussion? If not, all in favor say aye.
Aye.
Any opposed? All right, number 2.
Next complaint is complaint number 2023-052851. Complainant, who is the owner of a funeral establishment, alleged that a former employee of their funeral establishment placed an unauthorized ad with a local newspaper promoting the new name of the funeral establishment before the change of ownership and name applications were submitted or approved by the board. Complainant stated they did not give this employee permission to place the ad and attached an email from the publisher of the local newspaper stating that the ad was published in error and not authorized by the proper person. Respondent replied, stating that complainant had put him in charge of promotion regarding the new ownership of the funeral establishment. Respondent stated throughout the promotion they were careful to not promote the new establishment name until it had been approved by the state. Respondent stated at no time was he advised that he could not place ads without complainant's approval. Respondent stated that the ad referenced in the complaint was one of many ads prepared to be run in the future after the name change. Respondent stated this ad was placed without knowing the confirmed date of printing and publication. Respondent stated there was no intent on their part to run an ad with an unapproved name and no intent to violate applicable rules. Based on the above, we would recommend a letter of warning.
Move we approve council's recommendation, letter of warning.
Second.
All right, we have a motion by Mr. Berry to accept legal's recommendation, letter of warning, second by Mr. Lee. Any questions or discussion? If not, all in favor say aye.
Aye.
Any opposed? Number 3.
Number 3 is complaint number 2023-053441. Complainant alleged that on October 10th, 2023, they were informed by another individual that an associate of respondent establishment speculated that the reason an autopsy for the decedent was offered was because, quote, the hospital suspected foul play, end quote. Complainant stated they called the associate and, quote, strongly coached him on the appropriateness of this comment, end quote, and communicated that it was unprofessional. Complainant further claimed that they told the associate that they were completely unaware of the reason why the hospital offered an autopsy, and stated the associate should have encouraged the family to contact the hospital if they had questions regarding the autopsy. Respondent replied, stating that complainant had misconstrued their conversation with the decedent's family. Respondent confirmed that complainant was not part of their conversation with the family and that their information is not firsthand. Respondent explained that the wife of the decedent mentioned that a doctor from a hospital had called her multiple times wanting an autopsy done. Respondent stated they explained to the wife that, quote, most autopsies are done when foul play is suspected, which is not the case in this situation, end quote. Respondent continued stating that the decedent had numerous health issues and the autopsy was likely the doctor wanting to understand the specific cause of death. Respondent stated they met with the family several times and that anytime the autopsy subject was mentioned, they told the family that the autopsy had nothing to do with foul play. Based on the above, complainant admits the basis of their complaint is based upon a hearsay understanding of what respondent allegedly told the family. Respondent explains that they specifically mentioned that the autopsy was not due to foul play and confirms that complainant was not present for the conversation to be able to accurately know what was stated. Based on the above, we would recommend closure.
Council's recommendation of closure.
Second. Excuse me.
All right, I have a motion by Mr. Berry to accept legal's recommendation of closure, second by Mr. Lee. Any further questions or discussion? If not, all in favor say aye. Aye. Any opposed? Number 4.
Number 4, it's complaint number 2023-045331. Complainant, daughter of the decedent, stated that the services for their mother were changed. Complainant alleged that when they called respondent, they informed her that graveside services were at 12:30 and, quote, hung up and called the family member that was in charge of making the arrangements, end quote. Complainant alleged that they were intentionally given an incorrect time because respondent recognized their voice over the phone. Complainant further stated that during the services there were lawnmowers, blowers, and weed eaters, quote, from the time they arrived to the time they left, end quote. Complainant also alleged that when arriving at the church, they overheard respondent make a comment to the effect of, quote, oh, she just had to show up, end quote. Further, complainant alleged that respondent was rude and that when respondent sent the list of the decedent's wishes, they did not match what the decedent had wanted. Finally, complainant stated that members of the family that came to the church for the decedent's services had firearms holstered throughout the service. Respondent stated that on September 3rd, 2023, they received a call from a local hospital informing them of the death of the decedent. Respondent stated the next of kin, a daughter separate from complainant, had instructed them to release to their funeral establishment and that respondent had called the next of kin daughter and talked briefly about the types of services to arrange for the decedent. During this meeting, the next of kin daughter presented a final wishes paper that the decedent filled out and provided to the next of kin daughter prior to her death. Respondent stated that the next of kin daughter told her it was very important that they wanted to honor the decedent's final wishes and that respondent may be contacted by other family members expressing their wishes. Respondent stated the next of kin daughter asked that she refer any outside calls from other relatives to her. Respondent stated the day after this appointment, complainant called their office and identified herself as a daughter of the decedent. Respondent stated that the complainant was angry and stated that no arrangement should have been made without the entire family present. Respondent stated she explained that the funeral director does not decide who is present for the arrangement conference, but stated that complainant's mother's wishes were what guided the arrangement meeting. Respondent said the only actual decision made by the next of kin daughter were the date and time for the family visitation, and that some music be played during the visitation time. The final wishes document indicated that there be no organist or soloist during the visitation, but respondent included streamed music at the request of the next of kin daughter. Respondent further stated that the next of kin daughter had an appointment the following Wednesday at the cemetery, and that service times were not determined until after that meeting had occurred, so they could determine the cemetery's availability. Respondent stated they have no information to determine whether the next of kin daughter communicated service times among the family that ended up being inaccurate, but only knew that the cemetery personnel requested the 12:30 graveside time. At complainant's request, respondent sent a copy of the last wishes document to complainant, and the respondent contends that over the phone, complainant told her she, quote, better be sure you have security at that funeral, end quote, causing respondent additional concern. Respondent stated that the next of kin daughter provided her with insurance policy information in which she was the primary beneficiary. The policy had been pre-purchased by the decedent in March of 2019. Respondent further provides that the next of kin daughter was acknowledged as the next of kin because she had been listed as the informant on the certified death certificate and since she was the named beneficiary on the insurance information. Further, the next of kin daughter was also listed as the next of kin on the hospital discharge papers. Respondent denies that complainant was given an incorrect time or that an alternate time was given due to complainant's identity. Respondent stated they do not screen a caller's identification when inquiring about service time and that complainant was told the 12:30 time because that's the time everyone else was told. Next, respondent stated that there were not lawnmowers, blowers, and weed eaters present at the service, but instead that it was a tree trimming service. Respondent stated that they were trimming limbs for, quote, many consecutive days during the week of the decedent's service. Next, respondent stated they only met the next of kin daughter and her son in person and no other members of the decedent's family, so they would not have known to make any comment about complainant as they alleged, and further confirmed that no one had introduced her to complainant that day. Respondent stated she personally did not observe firearms at the service, but stated that her staff and pastor did notice one individual openly carrying a firearm. Respondent stated he was the grandson of the decedent and son of the next of kin daughter. Respondent mentioned that this individual spoke at the service and asked that the family, quote, please stop quarreling and try to improve their relationships with each other, end quote. Respondent stated she did not change the times for the visitation or graveside service and that the decision was made by the next of kin daughter and that neither her nor her staff were in any way rude as complainant alleged. Complainant also supplied an 11-minute phone recording between her and respondent. Highlights of this call include complainant acknowledging that the next of kin sister was left in charge, continued allegations of not following the decedent's wishes, though complainant acknowledges that respondent followed the document of final wishes that respondent had been provided. Complainant acknowledged that there were family issues and tension that extended beyond just the arrangement process. Complainant acknowledges that she asked respondent for her mother's wishes, acknowledges that respondent did as she was asked and provided the document, but appeared to take issue with the fact that respondent contacted the next of kin sister and her son as they had requested she do if she was contacted by other family members. Based on the above, the bulk of the complaint appears to be family-related issues. Respondent appears to have had sufficient reliance information to establish the next of kin sister as the next of kin and appeared to abide by the requests and wishes of the next of kin sister. While complainant may have taken issue with the final wishes document and decisions made by the next of kin sister, it appears that respondent followed the document and next of kin as they were instructed to do. Based on the above, we'd recommend closure.
I agree with counsel's recommendation. Just sounds more like family dynamics here. I'll make a motion that we accept recommendation and close this.
Okay. I have a motion by Mr. Lee to accept legal's recommendation of closure, second by Mr. Naylor. Any further questions or discussion? If not, all in favor say aye. Aye. Any opposed? All right, number 5.
Number 5 is complaint number 2023-050881. Complainant, a former employee of respondent establishment, alleged racial discrimination and harassment in the workplace. Respondent establishment replied denying the allegations as complainant had stated them. Legal attempted to send this case for investigation. However, after the investigator contacted complainant disclosed that he had retained legal counsel since filing the complaint. After legal discussed the complaint with complainant's counsel requested that her client not speak with the investigator at that time and that she would know more about how to proceed in 2 weeks. 2 weeks later, legal contacted complainant's counsel to determine how to move forward. In short, complainant's counsel felt that due to ongoing litigation, it would be pertinent to halt the progress of this complaint so that matters could be addressed in a separate jurisdiction. In an email dated November 17, 2023, complainant's counsel stated that they and counsel of respondent would request that this complaint be closed without prejudice so that a future complaint could be refiled in the future if necessary. Based on the above, legal would recommend closure of this complaint and allow for complainant to refile a separate complaint at a later date when or if the timing becomes ripe.
Motion to accept closure on this complaint.
Second.
All right, have a motion by Mr. Lee to accept legal's recommendation of closure, second by Ms. Haynes. Any further questions or discussion? Not all in favor say aye. Aye. Any opposed? Number 6.
Next complaint is complaint number 2023-028421. Complainant alleged that respondent establishment had mishandled the body of a decedent. Specifically, complainant alleged that the funeral director in charge failed to properly catalog decedent's clothing and belongings, the funeral director destroyed the decedent's clothing without authorization, and that the embalmer at the establishment had broken the decedent's ankles in order to fit him inside the casket. Respondent vehemently denied the allegations, stating that they treat all families in an ethical and respectful manner. On June 17, 2023, the complainant replied a rebuttal stating, quote, "I'm gathering multiple affidavits in this matter and I will forward to you. I respectfully request you refrain from issuing a final decision before I get this evidence to you," end quote. As of this date, complainant has not supplied any additional information. This complaint was sent for investigation. First, the investigator spoke to the general manager and licensed funeral director for the respondent establishment. The general manager stated his familiarity with this matter was all secondhand as it had occurred prior to his time with respondent establishment, which began in 2021. The investigator inquired as to whether respondent establishment had a protocol as to a decedent's personal effects. The general manager stated that they have a chain of custody and provided the investigator with a copy of that form. Next, the investigator met with the funeral director referenced in the complaint. The funeral director stated that they were the manager of the respondent establishment at the time the complaint was filed by complainant. The manager / funeral director stated that on July 20, 2020, respondent received a death call from a hospital and that their staff made the removal of the decedent. The funeral director manager also provided the name of the embalmer who had embalmed the decedent, but provided that they no longer worked at the respondent establishment. The manager funeral director recalled the timeliness of making funeral arrangements with the family. Recalled the timeline of making funeral arrangements with the family on July 21, 2020, visitation occurring on July 24th, 2020, and funeral services on July 25th, 2020. Thank you. The manager funeral director stated that they were the one involved with making the funeral arrangements, conducting the visitation, and the funeral and interment services. When asked about the protocol for personal effects, the manager funeral director stated that respondent establishment staff would place any jewelry or personal effects in a plastic bag, and the bag was placed above the embalmer's desk with the name of the deceased and date of death. They continued that any clothing was placed in a paper bag with the name of the deceased and date of death on the bag. The manager funeral director stated that it appeared from the medical release form the clothing may have been removed by medical staff, and provided that the release form stated the shoes and socks were given to the mother of the decedent. The manager funeral director stated that to the best of their recollection, no additional personal effects were given to the funeral home at the time of the removal. Next, the investigator met with another funeral director at respondent establishment. This funeral director stated they began employment at a respondent establishment in 2013. The funeral director recalled the embalmer who had embalmed the decedent and stated that he had performed approximately 90% of all embalmings at the respondent location. Funeral director stated, to the best of their recollection, they did not assist the embalmer with the dressing or casketing of the decedent, and recalled that they were not involved with assisting the family in question with funeral services. The funeral director stated they never spoke to the family and absolutely denied ever speaking to the family regarding the allegedly broken ankles of the decedent. The funeral director explained that in the event a person was too tall to fit in a casket, the ankles would never be broken, but instead the knees could be gently bent with a pillow placed under the knees. Next, the investigator met with the embalmer who had embalmed the decedent for respondent establishment. The embalmer confirmed that he had never met the family as his duties were limited to embalming, dressing, and casketing decedents. The embalmer provided that if there were any personal effects, those items were bagged and kept in the preparation room area for a reasonable amount of time, and that any personal items of value or items that needed to be returned to the family were given to the funeral director making the arrangements with the family. The embalmer vehemently denied ever breaking the decedent's ankles so they could fit in the casket. Next, the investigator attempted to meet with the mother of the decedent. After nearly a month of organizing attempted meetings and no shows from the mother after a scheduled time and place had been decided, the investigator was finally able to meet with the mother of the decedent. The mother stated that upon arriving at the hospital, realizing her son had passed away, her son was still wearing the clothing he had worn when he was brought to the hospital. The mother stated that the clothes appeared to have been cut to allow medical staff to attend to him, but that the clothes were still on his body. The mother stated that there was no blood on the clothing and that a nurse at the hospital gave her socks and shoes that belonged to her son. The mother stated she later inquired as to where the remainder of her son's clothes and his silver cross, and she was informed by the nurses that they had been sent to respondent establishment along with the body. The mother confirmed that the manager funeral director was present and had assisted the family with arrangements and was also present for the visitation and funeral services. The mother stated that when the family conducted a private viewing, the embalmer escorted the family to view the decedent in the casket. The mother stated she requested that the embalmer open the foot end of the casket because she wanted to see the entirety of the decedent. The mother claims that the embalmer was, quote, reluctant but agreed, and that she was surprised to see her son's feet were contorted in an unnatural position. The mother alleged that the embalmer stated, quote, "Sometimes we have to do that to fit them in the casket," end quote. The mother stated a few days later she met with a hairstylist to fix the decedent's hair, and that after she had had the opportunity to do so, the hairstylist gave the decedent's silver cross to her. The mother stated she inquired several times of the manager, funeral director, and another employee about retrieving the decedent's clothes. The mother stated that both employees stated they would return the son's clothing to her, but that the mother never received it. The mother stated 1 month after the service, she called respondent establishment again inquiring about the decedent's personal effects, and was never given a direct answer. The mother again contacted the nurses, who purportedly stated the decedent's personal effects were placed in a bag with his cross, and it was sent to respondent establishment. The mother then contacted the manager, funeral director, who she claimed stated that the hospital had thrown the decedent's clothes away. However, the mother contended that when they told the manager, funeral director, the nurses had informed her the clothes were sent to the respondent establishment. The mother purported that the manager, funeral director, then changed their story and said that the decedent's clothes were biohazard and that the respondent establishment had thrown them away. The mother also contended that the manager, funeral director, was rude and unprofessional on several occasions and purported to have a recording as proof. However, after several months of requesting these recordings, they were not received until November 28, 2023. After listening to the recordings, it does not appear that the manager, funeral director, was ever being rude to the mother. Next, the investigator met with the chief nursing officer, market president, and compliance manager at the hospital where the decedent had died. However, the employee stated that due to HIPAA regulations, they could not provide any details of a patient, including their personal effects. However, one of the employees stated that it was hospital policy that all personal effects of the decedent be given to the family or sent with the decedent to the funeral establishment making the removal. Next, the investigator met with one of the nurses who had treated the decedent. Again, due to HIPAA regulations, the nurse refused to discuss the matter with the investigator and refused to provide a statement. Next, the investigator met with the hairdresser, who stated she had been acquainted with the mother and decedent for numerous years and had styled the decedent's hair on numerous occasions. The hairstylist stated while styling the decedent's hair, she recalled seeing some of the decedent's personal effects on an adjacent table. The stylist stated after she completed styling and met with the mother of the decedent, the mother asked if the silver cross necklace was in the room with the decedent. The stylist stated she asked the embalmer if she could take the cross to the mother, but could not recall the outcome and did not want to be misquoted. Finally, the investigator contacted the complainant and requested that he provide him with any information, documents, or affidavits as he had referenced in the rebuttal. The complainant stated that due to pending litigation, he would not be willing to provide any information or to provide a statement at this time. Based on the above, while it appears that the manager funeral director does not recall whether the personal effects of the decedent were received by the respondent establishment, several affiants recall seeing the decedent's personal effects at the establishment. Okay.
All right, Mr. Bryant, we'll turn back to you. Sorry for technical difficulties there.
I will just take that paragraph from the top. Based on the above, while it appears that the manager funeral director does not recall whether the personal effects of the decedent were received by the respondent establishment, several affiants recall seeing the decedent's personal effects at the establishment. The evidence appears to show that the decedent's silver cross was returned to the mother of the decedent. However, the evidence suggests that the clothes that were torn were not returned to the mother. From legal's perspective, while it is potentially understandable to dispose of ripped or torn clothes, it is ultimately up to the determination of the next of kin as to how to dispose of, if at all, the decedent's personal effects. No evidence was present other than the recollection of the mother that the decedent's ankles had been broken as alleged. Further, there was no proof that respondent staff, specifically the manager funeral director, had been rude to the decedent's mother as alleged. Based on the above, we would recommend a letter of warning related to the alleged disposal of the decedent's clothes.
Did the respondent have any paperwork to show any personal effects that they took possession of at the removal?
They did not. I know one of our things we asked for was kind of that paper trail of if there was any documentation or anything to that effect. And I know the investigator told me that they weren't able to procure that, so that was not in the file.
Make a motion that we approve council's recommendation of letter of warning.
Second.
All right, I have a motion by Mr. Berry to accept legal's recommendation, letter of warning, and second by Mr. Lee. Any further questions or discussion? All in favor say aye. Aye. Any opposed? All right, number 7.
Next complaint is complaint number 2023-036291. Complainant, an employee of the medical examiner's office, alleged that respondent had cremated without the proper authorization in place. Specifically, complainant stated that on July 18, 2023, respondent submitted a request for cremation approval for a decedent, along with a certified death certificate signed by an attending hospital physician. Complainant stated that the cause of death listed was not sufficient for initial approval, and that medical records were requested on July 19, 2023. Complainant stated that respondent was sent written notification via email that the approval for cremation was pending until the records could be obtained and reviewed. Complainant stated they received the records on July 21st, 2023, and after review determined that a physical examination of the decedent was needed. However, upon reaching out to respondent, complainant was advised that the decedent had already been cremated. Complainant alleged that this had been carried out without medical examiner approval, without a permit from the health department. Respondent replied stating that the decedent died on June 22, 2023, and that the hospital released a respondent establishment. At the request of the family, the respondent establishment began working towards cremation, and a cremation permission form was sent to the medical examiner's office for approval on July 18, 2023. On July 19, 2023, the mother of the decedent signed all appropriate documents for cremation. Respondent stated the same day, respondent establishment talked to the medical examiner's office where verbal authorization was given over the phone for cremation. Respondent contends that it is not uncommon for funeral homes to receive verbal confirmation from the medical examiner's offices for cremation. Ultimately, the decedent was cremated on July 20th, 2023. The following day, on July 21st, 2023, respondent received a call from the medical examiner's office indicating that the decedent needed to be brought into the medical examiner's office for an exam. However, respondent establishment indicated that they had already received verbal permission to cremate from the medical examiner's office. After this call, respondent stated they checked their email and saw an email from the medical examiner's office indicating a chart review was needed on the decedent. The complainant contacted the office manager at respondent establishment to verify if the decedent had been cremated, and after this was confirmed, respondent purported that complainant said, quote, "it was no problem," end quote, and that she would just do a chart review. However, complainant called a second time and indicated that her boss had requested her to file charges against respondent, stating that since the decedent was only 20 years old, there was no way the cause of death listed on the death certificate was correct. Respondent stated that although complainant indicated that the respondent had been cremated without authorization of the local health department, according to an email dated December 23, 2020, coming from the state health department, local registrar signatures were no longer required for cremation permits. This case was sent for investigation. First, the inspector spoke to complainant, who confirmed that they had received a request for cremation from respondent on July 19, 2023, and that the request was reviewed by the death investigator. After observing and opining that the cause of death listed was insufficient, they determined that the decedent's medical records would need to be reviewed prior to issuing cremation approval. Complainant stated the medical records were received, and on July 21, 2023, it was determined that the decedent would need to be examined. Complainant contended that at no time was verbal permission to cremate granted by a staff member of the medical examiner's office. Complainant explained that the protocol for granting permission by the medical examiner's office was that after granting permission, a medical examiner form was completed and sent to the local health department. Complainant continued that after the medical examiner form was sent to the local health department, a death investigator would contact the funeral establishment and notify the funeral home that the medical examiner form had been sent to the health department. From there, the funeral home would go to the health department and obtain the permission form. Complainant stated that there was no authorization form submitted by the medical examiner's office to the health department for the decedent. The investigator interviewed the office manager for respondent establishment. Respondent stated that on or about June 28, 2023, the decedent's mother and grandmother came to respondent establishment to make arrangements for the deceased. Originally, the family hoped to have a funeral service, but due to finances, several weeks later requested that the decedent be cremated. On July 18, 2023, respondent sent the decedent's mother a text message stating that the death certificate had been completed and was available to be picked up. When the mother came in to pick up the decedent's ashes, she signed the necessary paperwork for the cremation approval forms. These forms were signed by the decedent's mother on July 19, 2023. The previous day, July 18, 2023, respondent had made the request to the medical examiner's office for permission to cremate the decedent. Respondent stated she spoke to an employee at the medical examiner's office. Respondent was able to recall the first and last name of the purported individual she had spoken with over the phone, and that this employee had given verbal permission to cremate the decedent. Respondent stated they did not get a permit from the health department per instructions received in an email from the health department sent on December 23, 2020. Respondent confirmed that on or about July 24, 2023, they were contacted by the medical examiner's office requesting to examine the body. Respondent stated they informed the employee that the decedent had already been cremated via verbal permission from the previously named employee. Respondent stated that when complainant called them the next day stating no permission had been granted, respondent checked their emails and found an email in their spam inbox indicating the medical examiner's office wanted to do a review of the remains of the decedent. Respondent contends that at that time, complainant informed her that everything was fine as they would just conduct a chart review. However, respondent stated that complainant called back later and informed her that complainant's supervisor had requested that respondent be reported. Respondent stated this was an isolated incident and only occurred due to a breakdown in communication between respondent establishment and the medical examiner's office. The email referenced by respondent from December 23rd, 2020 stated the signature of the health department is no longer required, states as follows, quote, "We have heard several concerns that the need for a local registrar's signature on cremation permits is unnecessary and is delaying cremations unnecessarily. We are in the process of removing the local registrar's signature line from the cremation permit form. The form change, approval, and redistribution is estimated to take 90 days. Starting today, 23 December 2020, the interim solution going forward is that the medical examiner's signature will be the only authorization needed on the current form," end quote. Legal contacted the individual at the Department of Health who had sent the email in question. In short, as legal understands it, respondent correctly understood the original intent of the email from the Department of Health, as it applies to a total of 89, primarily rural, county health departments that operate under the Tennessee Department of Health in Nashville. Excluded from jurisdiction of the state health department are Hamilton County, Knox County, Madison County, Metro Nashville, Shelby County, and Sullivan County. As the State Department of Health employee stated, the intent of the email was to cut the local registrar/county health department out of the equation because Verism had essentially automated the local registrar's responsibility, which would help with the expedition of cremation permits. However, the employee stated that the Department of Health does not have jurisdiction over the metro counties, and that the metro county respondent resides in had decided to continue with the local registrar's responsibility in contrast with the email. It is unclear if a follow-up email from either the state or county departments of health was ever sent explaining this discrepancy. Based on the above, while the respondent made a mistake in cremating without the proper approval, the mistake seems to have been a reasonable one to make given the December 23, 2020 email they received. Although an argument could be made that it is incumbent upon the respondent to understand their duty and responsibility when conducting cremations, an argument could also be made that upon receiving communication from the state about an update to the cremation approval process, one would follow the guideline provided by the state, particularly if they were unaware of the nuances of county, municipality immunity, and jurisdictional lines. However, the respondent clearly never received any type of written approval for cremation from the medical examiner prior to the cremation. Based on the above, we would recommend a $500 civil penalty plus the cost of investigation, authorized via consent order in a formal hearing if necessary.
To me, it's like the respondent negligently cremated. We've never been able to cremate with a verbal, in my opinion, where I'm from. You always have to have the medical examiner's signature. So to me, they neglected that part. And one of the counties mentioned, yes, they do not have to sign it, but we still send it to them because we have to pay that $25 fee. So there's multiple things there. I don't know. Is there a reason why it's just $500? To me, there's a lot more to this for that fee.
Sure. And I will say too, I may be missing it as someone who is not a funeral director and has gone through this process. Kind of my perspective of it on the outside looking in is that not my intent to throw anyone under the bus. I know everyone did the best they could. I have zero doubts about that. But I feel like better communication from multiple parties could have solved this. I don't know if I am the medical examiner's office. I'm just sending an email to say, wait, please don't cremate. Because that does happen. It can go to a spam box. They may not see it. I think that's a phone call. And they did get a phone call a few days later after they had reviewed the medical records. I also don't know why, if I'm sending an email out saying, hey, you all don't have to jump through this hoop anymore, if there's kind of a nuance to, well, you still do if you live in these jurisdictions. That may have been explained. It may not have been. I really don't know. I also don't know if any communication was ever made from the county that they were in saying, we understand you got an email from the state health. We're in a separate jurisdictional setup, so we're still going to require you to do that. It feels like if communication had been kind of improved in other places, it could have been avoided. I still think the brunt of it, which is why it's a recommendation of 500 plus investigation costs, which are not insignificant. They're still, they made the mistake and they're still taking the brunt of that penalty. But that's why, rather than increase the amount, it felt like, while a mistake, I feel like there were some other places that could have been shored up to where this wasn't avoided.
Just to say a couple of things now that Mr. Batson's in the room back there. We all got that same email, and we had in our western end of the state a snowstorm which shut down our health department for a week. We were backing up in cremations. So we made the call to Dr. Adele Lewis here, which helped us get through the hump. But the email did not state what health departments were doing it and were not doing it, but we received, I did personally, from our medical examiner's office that the Shelby County, in our jurisdiction, was not involved in the ones that were waiving that. And I'm sure just listening to the complaint, everything sounds kind of familiar, Mr. Naylor, if you've ever requested one in West Tennessee. So the way this works is when you send a cremation request, not the permit, you send a request to our medical examiner. If they approve it, they call and say, you have permission to cremate. We're sending this to the health department at such and such time. We then send the permit to the health department, and they staple it to the medical examiner's authorization. All of that being said is, I do not doubt the funeral director got a call that said you have permission to cremate, but we know you've got to follow up to get that actual permit. So there's, you know, we tried to find out when the health department was going to really come back and redo the forms or tell us what counties we're in. They never have. And this is the first I've seen of what you were able to find out. You know, we've gone almost 3 years not knowing. So, but it does concern me that there is an assumption that this funeral director could be doing all the cremations based on verbal permission. And that's something, you know, we don't know, but I would hope that he's following up and doing everything. So I can see that he got that phone call. That
So you're
gave him,
saying in your area you can cremate with a verbal?
No. What I'm saying is the medical examiner is going to call me and say, hey, we got your form. You've got permission to cremate. We're going to send it over to the health department either at 11 or 3. Then we fax our permit over there. Now, just to give you an idea, there's 2 counties in West Tennessee. The medical examiners are up in age, and that's the only way they do it. We write verbal on there, then we mail them the copy later with the death certificate, and they send it back for their file. So that's very small counties. So
Our permit goes straight to the ME's office. So that's why I'm asking.
yeah, no, it's different. And in our area, my county, when we do cremations that died in my county, we keep a folder, and instead of going to the health department with every one, they like it where we take 10, 15 a month and just pay for it. So
But I think where I have a problem is they still cremated without a signed medical
yeah, they never
examiner.
had the permit because you don't send the
Yeah,
permit
I mean-
to the medical examiner's office.
Clarify again, what did the ME investigator go to the ME's office?
I kind of read that, Fred. I thought. They
Yes.
interviewed-
So the complaint, I'm trying to keep them all straight. The complainant was an employee at the medical examiner's office. So the investigator went there, spoke with them, kind of learned what the process was, and their version is kind of, we would never have given verbal permission. I will say to what Mr. Lee is saying, that seems pretty similar. Kind of that process is what we've heard kind of, I think, most likely happened. But the investigator did speak to the medical examiner's office.
Be interested to know what the medical examiner would say about that, and if they say it is common for them to give verbal or versus. I don't know if the complainant was an actual ME or an administrative staff person or who.
They claimed it was not, that they just don't give verbal permission. Though I will say it's hearing Mr. Lee kind of say his experience, which I think is similar, if not identical, to what happened here about that call you get saying you have permission, we're going to send that on. To me, that becomes kind of a thin line of saying, yes, you have permission, you're good to go, black and white, we're done, and you have permission, this is gray, we're going to continue to send it on in the process. I think that's where the miscommunication occurred.
Hey, I mean, on a daily basis. So
I agree with counsel's thoughts that communication could be approved by all parties. So I guess we have power to make that happen. So
That'd be a real miracle worker, I think, just in general, not with these parties specifically, but just.
I'll make a motion to approve council's recommendation.
Second.
All right, I have a motion by Mr. Berry, second by Ms. Haynes to accept legal's recommendation of $500 civil penalty plus the cost of investigation, authorizing via consent order and formal hearing if necessary. Any further questions or discussion? If not, all in favor say aye.
Aye.
Any opposed? All right, number 8.
Number 8 is a represent. This is complaint number 2023-03151. This matter was previously presented at the August 29th, 2023 meeting as follows. Complainant alleged that respondent funeral director failed to file the death certificate in a timely manner. Specifically, complainant stated that the date of the death for the decedent was April 25th, 2022. Complainant stated that respondent did communicate that there was a backlog, but that they went to the county's health department several times and stated that they did not have records. Complainant stated that the main purpose of the complaint was in order to receive the death certificate. Respondent replied, confirming the date of the death as complainant has described. Respondent explained that the hospital the decedent died at refused to sign the death certificate because they were not the primary physician for the decedent. Respondent further stated that at a separate hospital, they were told by the hospital that, quote, the floating physician wasn't signed into the system, end quote, and that no other doctor would sign off on the certificate. Finally, respondent said because no other physician would sign the certificate, they had no choice but to send it to the medical examiner's office, and that as of the date of their response, July 10th, 2023, they were still waiting. Legal's recommendation at the time was a $1,000 penalty to be reduced to $250 if that death certificate was provided to the family within 30 days to receive the consent order, as well as a letter of instruction that included language as to how kind of the steps you should go through if you're running into that issue. The board asked that it was sent for investigation to get further information regarding information made available from the medical examiner. So first, the investigator confirmed with the office manager of the county health department that the death certificate of the decedent had not been filed in Verizon. Second, the investigator spoke to the senior investigator at the forensic center of the medical examiner. The senior investigator provided that the death certificate for the decedent had been created on October 18th, 2022, and had been assigned to an unlisted physician and had been assigned to the medical examiner's office on July 10th, 2023. The senior investigator provided that the decedent had died as an inpatient in a hospital and that the death certificate should have been signed by a physician at the hospital. During the interview, the senior investigator stated that he would request records from the hospital on the decedent and contact the department's investigator whenever they had the information. On November 10th, 2023, the department investigator contacted the senior investigator requesting an update on the information they indicated they would provide. The senior investigator stated that the medical examiner's office had not received the requested information. Third, the investigator spoke with respondent. Respondent stated that the decedent was the brother of the owner of the funeral establishment that she worked for, and that the funeral home had handled the arrangements and internment services for the decedent. Respondent explained that the decedent died at a hospital on April 25th, 2022, and that the death certificate was sent to the hospital to be signed and a cause of death to be completed by the doctor. However, respondent explained that the doctor informed her and the funeral establishment that the death certificate would be sent to the VA hospital, where the decedent had previously been an inpatient. Respondent confirms that the death certificate was sent to the VA hospital, but that the doctor there refused to sign the death certificate. Since neither doctor agreed to sign the death certificate was sent to the medical examiner's office to allow the medical examiner to sign it. However, respondent stated that soon after, the medical examiner contacted respondent in the establishment requiring that either a doctor from the VA hospital or the hospital the decedent died at would need to sign the death certificate. Respondent stated that the establishment had done everything they could to get the death certificate signed, but to date, no doctor or the medical examiner would agree to sign the death certificate. Respondent provided that in all her years in funeral service, she had never had any problem getting a death certificate signed. Finally, the investigator spoke to the owner of the establishment, who is also the brother of the decedent. The owner confirmed that his brother had died on April 24, 2022 at a hospital, and confirmed that prior going to this hospital, his brother had been an inpatient at the VA hospital. The owner stated prior to sending the death certificate for signature, a doctor from the hospital indicated she would be willing to sign, but later, once the death certificate had been available for signature, the doctor refused to sign it. The owner further confirmed that he sent the death certificate to the VA hospital, but again, no doctor would agree to sign it. Following this denial, the owner stated he contacted Vital Records several times, but did not receive assistance. The owner stated he had exhausted all efforts in trying to get a doctor to sign his brother's death certificate and was at a loss for what else to do. The owner provided that prior to this instance, they had never had an issue with a doctor to sign a death certificate. Based on the above, it is unclear exactly how involved with this process respondent themselves were. That is, although it is clear that respondent as an employee of the establishment was involved in this matter and has knowledge of how the issue involving the signatures has progressed, it appears from the interview that the owner was the one primarily involved in trying to get their brother's death certificate signed. That is, it is unclear what, if any, violation respondent is directly responsible for. Furthermore, both the respondent and the owner went into great detail regarding the efforts they have gone through in trying to have the death certificate signed. With two separate physicians denying signature, multiple contacts to Vital Records, and sending the death certificate to the medical examiner's office, and again receiving denial to sign the certificate, it is unclear what additional efforts respondent may have taken. Further, the challenge and difficulty in having these three separate groups, hospital, VA hospital, and medical examiner's office, to coordinate to determine who should sign the death certificate was on display during the course of the investigation, as the senior investigator, to legal's knowledge, never contacted our investigator with the requested information. Based on the above, we would recommend closure.
Do we approve council's recommendation for closure?
Second.
All right, I have a motion by Mr. Berry to accept legal's recommendation for closure, second by Mr. Lee. Any further questions or discussion? Not all in favor say aye. Aye. Any opposed? All right, number 9.
Number 9 is a represent from last month's board meeting. It is complaint number 2023-037651. It was previously presented as follows. Complainant, funeral director appointed as establishment manager, alleged that the owner of a respondent establishment is making decisions without complainant's knowledge. Specifically, complainant referenced 2 cremation cases where respondent was initially called and they later transferred and serviced the calls through a separate location in an adjacent state, but provided that they, complainant, had not been notified or contacted regarding the 2 cases. The Director of Operations, Marketing Director, and Business Manager for respondent, not a licensed funeral director, replied stating that there had been considerable tension between he and complainant after a workplace dispute. Respondent stated that complainant informed him in the middle of July that complainant and her husband would be leaving town for a week or so. Respondent stated he requested that complainant call him when she returned. Respondent contends they never received this call and that at the time of the response, August 14th, 2023, they had not had any communication with complainant since she indicated she would be going out of town. Thus, complainant was never involved in those cases because complainant had not contacted respondent. Further, respondent provided that the two cremation calls were transferred to their location in Mississippi, where their Mississippi funeral director at their Mississippi location handled all arrangements via email and phone calls with the family. Respondent stated that complainant could not have handled those two calls anyway because complainant is not licensed in Mississippi. The Mississippi funeral director is not licensed in Tennessee. The calls were initially received at their Tennessee location. Additionally, respondent stated that one set of cremated remains were returned to the Tennessee location. There was no Tennessee funeral director involved in the process. Furthermore, there was no Tennessee licensed funeral director covering for the then establishment manager who was out of town, and no Tennessee funeral director involved in either of the two cases where the death calls were initially received by the Tennessee establishment. The complainant had notified the department they resigned from the establishment effective June 13th, 2023, and the Tennessee funeral establishment did not have any licensed funeral director employed from mid-June until July 13th, 2023. We had recommended a $1,500 civil penalty, but the board said that they would like a little bit more information, specifically kind of the timeline of what the families did or did not understand regarding the Tennessee establishment. So, respondent provided the following information for the two families. For the first family, respondent stated that the decedent was an elderly, indigent lady in a nursing home. The decedent had no family as they were all estranged. Respondent stated that a nursing home called and asked if the establishment could help, and they offered a direct cremation for $395. Respondent stated the decedent was picked up and transferred to the Mississippi location, and a funeral director there got the information they needed by phone. An estranged niece eventually agreed to sign the cremation authorization form. The niece came to the Tennessee location to sign. Respondent stated the nursing staff was told that the decedent would be transferred to Mississippi for cremation and informed them that their Tennessee funeral director was on vacation and that the funeral director from Mississippi would be calling to set everything up. Respondent stated the only work done in Tennessee was the signing of the cremation permit. The death certificate was filed in Mississippi. For family 2, the family chose to use the Mississippi location as they did not know there was a Tennessee location. The cremation authorization form was signed by the family, and the decedent was picked up at a nursing home in Mississippi. After the family realized there was a Tennessee location, the cremains were picked up from the Mississippi location, and payment was made at the Tennessee location. In short, the decedent died in Mississippi, was picked up and transported to the Mississippi location, and the cremains were picked up at the Mississippi location. Respondent stated that only the payment was collected at the Tennessee location. Respondent stated all the information was gathered by the Mississippi location and that the death certificate was filed by the Mississippi location but had the Tennessee address on it. Based on the above, although it appears that neither family that was serviced during this time was under the impression or were misled to believe that their services would be conducted in Tennessee and Tennessee alone, the fact that the niece with the first family came to the Tennessee location to sign the cremation authorization, the fact that the nurses were able to call the establishment to request assistance in the first place, and the fact that payment was collected at the Tennessee location regarding the second family shows that at the very least, the respondent establishment was open, conducting business, despite lacking a licensed funeral director acting as manager, nor any Tennessee licensed funeral director for that period of time. And based on that, we would recommend a letter of warning.
I guess my question would be, because they did sign an authorization at the Tennessee location, correct? Did I read that right? The niece did?
I believe that's correct. Let me go back and double check. Yes. Yep. The niece came to the Tennessee location to sign.
Was business performed at the location? So how are we going from a 1,500 to a letter of warning? There was still business conducted.
Yeah, so before, for the 15, that was with a lack of information that I'm glad the board requested that we try and get. That was when I think we were looking at a potential worst case scenario of we don't have anyone here who's licensed, we don't have a licensed manager attached to this silo, and we're open conducting business, we're taking calls, people have no idea, we're outsourcing to Mississippi. Thankfully, it doesn't appear that that's the case here. What we do still have is, I guess, what you would call more, I don't want to say it's not significant business, but I would say more minor business at least. There aren't large, services going on while this licensed director is not at the location. So the reduction from 15 to a letter of warning is essentially with now this new knowledge that it was not, I think, what we all kind of feared before, is that it was open business as usual with no licensee and then sending it to Mississippi without anyone ever knowing. So that's the basis for the reduction.
Well, with cremation, it's created lots of gray areas, and I mean, lots of documents are now sent electronically and signed, and who actually sends the document? Did a licensed funeral director send the document? Did an administrative person send the document? You know, what would the law dictate should be happening with that? There's just a lot there that, you know, I would think if somebody was coming to a location to sign a cremation authorization, that the person they should be meeting with is a licensed funeral director. And if it's a Tennessee location, it should be a licensed funeral director from Tennessee. But this doesn't state that it was even a licensed funeral director from Mississippi that came. So who was it? The receptionist that met with the family and allowed them to sign the cremation authorization? But again, do you have to be a licensed funeral director to have a paper in front of a person to sign? Or so I think the intent of the law is that somebody that's dealing with a family with a cremation authorization is a licensed director. It would have been better off to electronically send it. And it, you know, brings up the question, and when you're seeing today, I mean, a lot more smaller businesses that are operating with very small staff with only one licensed director. So when a licensed director does take a vacation, whether it be a week or 2 weeks, and you know, can that business operate while that licensed director's away or out of town, or you know, that business may only have one licensed director. Certainly couldn't meet with a family and arrange for a cremation, I would think. But, you know, some of this talks about if the place of business is open, receiving calls, things like what, you know, does that require a licensed director to be available? How close do they have to be to the facility? There's just, again, there's so many questions regarding that. And I think down the road, there's going to have to be some clarity to that, you know, either given through the rule process or through legislation. As we have more complaints that come to this board of a similar manner that involves all this grayness, I think it's going to require something to be done.
Does the law not state that a director would have needed to have been present for that signature on the authorization? Do we
That is my understanding, that for the signature of that, there needs to be a licensed funeral director to witness the signature. And I guess one thing that we don't know entirely is that we know there was not a licensed director operating as manager at that time. That's what we know for a fact. That's undisputed. What I suppose we don't know is, as Mr. Berry was talking about, is this one of those very small staffs that only has the one licensed director? Is there another one present who did witness the signature, but they're not a manager? So I guess that's a potential remaining question of what are we talking about? We know there's not a manager. We know that for sure. Was there another licensee there? That's, I guess, the remaining question. But that's, I think, for kind of the intent of the recommendation of a letter of warning, is that we do know at the very least there was not a manager there during that period. And that, as Mr. Berry said, kind of tiptoeing up to and arguably into these gray areas about what kind of passes that line. So that was the intent with the recommendation of letter of warning. Though if there are other concerns, of course, like I always say, feel free.
I just think it warrants more than a letter of warning. That's my opinion.
Respondent did not state or make it clear who was present there. If I was making that response and I knew there was a licensed person there, I certainly would have made that. I may have to make the assumption that there wasn't a license. Can be dangerous to assume, but
I'm going to step out here and make a recommendation to change it to a $500 penalty with a letter of instruction going forward to make sure that there is a licensee doing this. That's my motion. We'll see if it gets second.
Second.
All right. So my motion was to change from a letter of warning to a $500 civil penalty with a letter of instruction. Second by Mr. Naylor. Any further questions or discussion?
Is that based on the assumption that there wasn't a licensed funeral director there?
Correct. I mean, we don't.
Is that what the recommendation is?
That's my thoughts on it because it looks like the Mississippi firm handled it. We don't know that a licensee was the one witnessing the authorization.
it did state that the licensed person was out of town. Didn't indicate there was another licensed person. So it may be a safe assumption.
But if you was not trying to clean up the mess, you would have said it was a licensed funeral director.
Exactly.
I don't even send in probably a copy of the paperwork, anything to show that. I just wanted to.
Yep.
I feel better with what y'all have said.
Any further questions or discussion on this matter? All in favor of the motion, say aye.
Aye.
Any opposed? All right. That looks to be the end of legal report. Anything else from you, Mr. Bryant?
That is all I have. Thank you.
Thank you.
Thank
as
you.
always.
Appreciate it. All right. We will move along to Mr. Gribble's Executive Director's Report. Good morning, sir.
Morning, board members and Mr. President. Legislative update is basically the same this month as it was last month. We've not officially been contacted by either the Tennessee State Funeral Director and Morticians Association or the Tennessee Funeral Directors Association regarding their intent to pursue new legislation during the upcoming legislative session affecting this board. However, the Tennessee Funeral Directors Association has verbally expressed that they are considering items that would affect the burial services section of the department. And as always, we extend an invitation to both associations and any other interested parties that would like to meet with their staff and legal counsel prior to the introduction of legislation. Licensee report is a report of licenses administratively approved by the Executive Director pursuant to Board authority for the period of November 9, 2023 through December 8, 2023. And you have a list of those there in front of you. Closed establishments. There are 2 establishments that have reported closing since the last board meeting. Gardens of Memory Funeral Home Cremation Services at 415 North Chantry Street in McMinnville, and Milldale Chapel, 8278 Highway 49 East in Springfield. The disciplinary action report is a report of consent orders that have been administratively accepted and approved by the Executive Director pursuant to Board authority, and as reported on the October 2023 Regulatory Board disciplinary action report. And you have those listed there for you as well. And lastly is the complaint report. And as of December 8, 2023, we had a total of 42 complaints. 22 of those pertain to funeral directors or embalmers, and 20 of those pertain to establishments. That's my report for today. I'll be glad to answer any questions you have.
Anyone have questions for Mr. Gribble?
Move we approve the director's report.
All right, I have a motion by Mr. Berry to accept Mr. Gribble's Executive Director's report, second by Ms. Haynes. Any further questions or discussion? If not, all in favor say aye.
Aye.
Any opposed? All right, thank you, sir. Anything else from you before we move along?
Thank you.
All right. Applications for licensure. Do we have any individuals or establishments today?
And today.
All right. So none to appear today. We'll move to new business. Any new business that we need to discuss? All right. We'll move along. Public comment related to items on the agenda. Ms. Bohannon, did anyone sign that today? No. All right. With none signed there. Before we do take a motion to adjourn, I would like to, as this is my last meeting officially, we probably will go forward until somebody's reappointed, but I would like to say thank you for the opportunity to serve with each of you. It's been a pleasure. It's been a distinct honor, especially this year, to serve as your president. Made a lot of great friends, learned a lot in this experience, and for the governor for appointing. And Mr. Gribble, for you and your office, job well done. I've got to see that firsthand, and I just want to say thank you. Anybody else?
Thank you.
Anybody else comments before we dismiss? All right.
Merry Christmas.
Merry Christmas and a motion to adjourn.
Second.
All right. Second by Mr. Lee. We are dismissed.